I found it quite a therapeutic exercise writing the book, given that there's so much happening in this space, particularly over the last few years, and I found that there's quite a body of law actually being developed in this area. I'll just take you through. I mean, I've had a lot of questions over the last week or so, so why a book? I think certainly there's a lot of issues around, you know, the differences between paper and issues in dealing with metadata and with email and other electronic files, and also some of the Web 2 technologies that are coming to the fore. We're probably not dealing with them as digital evidence too much at the moment, but we certainly will be in the future. And I think there's certainly some interesting academic debates around what may happen, and we'll certainly see some of this happening in the courts in the near future. So the book really examines digital evidence from collection to discovery and then right through to trial. It's called Computer Forensics, Electronic Discovery and Electronic Evidence, which I know is quite a long title, but I sort of wanted it to really say what it is, really state quite clearly what it's about, and I think it's done that. I've tried to keep it fairly practical. Obviously, you know, I deal in digital evidence every day, and I find that lawyers in particular really want to know what some of the issues are. You know, if there's any legal decisions that have been handed down from the courts, what are they and how do they apply? And this is certainly, you know, things that are being discussed in courts quite commonly at the moment. So there's several chapters to the book. There's an introduction and a conclusion, and then I try to sort of really follow through the way in which electronic or digital evidence is handled in the legal sphere. You know, what is computer forensics, electronic discovery and electronic evidence, and how do they interrelate? What are some of the sources of electronic evidence? And obviously that's a growing body at the moment. The sources of digital evidence is changing ever rapidly. All sorts of new forms of media are coming to the fray, and they're changing, obviously. Maintaining the integrity of electronic evidence, and obviously this is an area where computer forensic impinges, and I know particularly in the criminal space that's particularly important, but it is becoming more important in the civil space as well, and nobody wants to have the integrity of their evidence questioned by a judge. Preparation of electronic evidence for trial. You know, what do you do with it? What are the court practice notes? I think we all are familiar with what those are, but what are the evidentiary requirements as well? I look at the Evidence Act and so on. And then how to present electronic evidence at trial, and of course the new Federal Court Practice Notes talks about preparation of electronic evidence for trial as well. And then I pose some questions as to the future of electronic evidence, particularly with legal study and with some of the Web 2 technologies and so on. I think we've all heard today, and I know there's a lot of familiar faces around here. You certainly know what a lot of the issues with digital evidence are, and I've just listed some of the issues there from the Sedona Conference principles. Some of the highlights, obviously the Federal Court Practice Note came out earlier this year, so there was quite a bit to talk about there. I think certainly a lot of practitioners are now implementing that practice note, and no doubt that will change over time. I know Joe spoke quite at length about the practice note and some of the key elements in terms of proportionality and other issues to consider in the breadth of digital evidence generally. Preserving the chain of custody, I think that's certainly something that we're faced with each day. And privilege, inadvertent disclosure. There's, Justice Einstein's just walked in. Thank you, Judge. I'll invite him to come up shortly. In fact, Judge, you were being mentioned earlier about being one of the leaders in dealing with electronic evidence and asking for information to be provided in an electronic format, the pleadings and so on. I think it was it? There she is. Catherine, is it? Karen, sorry. Just about in terms of asking for pleadings and other documents to be provided in electronic format to the court. Just in terms of privilege, and I think one of the cases that I talk about was where a forensic image had been discovered to the other side, and of course there were some privileged documents on the forensic image, and that sort of leads down the path of, well, what is a document? Is a forensic image a document? and I won't sort of go into the debate now, but I think it raises an interesting topic that, you know, a forensic image that potentially contains, you know, tens of thousands, hundreds of thousands of documents, can that be classed as a document for the purposes of the Evidence Act? Because you're actually discovering a number of documents, and should you be looking at those individually, because there is a risk that you're inadvertently disclosing to the other side potentially privileged material. Of course, there's always the issue of costs. Often costs and e-discovery go together. So some of the issues around that, and what are some of the solutions? Obviously, sure, there's a cost, but there's also technology available now which allows you to really save costs. So it's a converging area. So really this is all about the evidence management workflow, from collecting evidence using computer forensics, extracting, filtering and analysing using your e-discovery, right through to presenting in court. And tying that all together is the standards and protocols that are being developed by the courts and other areas. That concludes just the formal presentation about the book. I'd now like to invite you to drinks, and I'll invite Justice Einstein to just say a few words about this area of electronic evidence and electronic discovery. So thank you, and come and join us for a drink.